Welcome everyone. Thank you for joining our webinar this morning. My name is Tanya Lopez and I am the Marketing Senior Executive here at HLB Manjard and your moderator this morning. Today we are presenting recent developments and lessons learned in R&D, presented by our panel of experts, HLB Manjard Tax Consulting Partner, Mariana von Luken, and Catherine Bettram, who is a partner at Johnson Winter and Slattery. Today Mariana will cover an overview of the current R&D tax incentive, pitfalls and tips, what to do and how to avoid them, how the R&D changes will affect your business, followed by Catherine Bettram, who will discuss the timeline of disputes with AusIndustry and AAT and costs, lessons learned on the ground, how taxpayers can avoid an R&D dispute with AusIndustry, followed by Q&A. Now, without further ado, I'll hand it over to Mariana.
Good morning, everyone. So Wednesday today, hump day, as they all say, but good to see. Well, I can't even see you, so good to know that you're on the line. There has been some development in the R&D, so it's great timing to probably send the message out there. Now, I wanted to just sort of highlight and bring you into the R&D. I think I'd like to pour more here from Catherine towards the end there after I've gone through what the changes are. But effectively, if you look at it, since 2015-16, the R&D spend had been $17 billion. That's, you know, companies like yourself spending on R&D. This is what the Innovation and Science Australia has recorded. Let's just call it AusIndustry. They administer it all. So just for simplicity, AusIndustry basically has recorded $17 billion in R&D spend. But in 2018, 2019, it's gone down. So why has it gone down? I'll go through that in a minute. Next slide, please. So it's gone down. I think that it's more through consumer confidence more than anything else. But at the same time, there was a review done back in 2016. And that review was done by the 3 Fs, that they call it. I think you had to have F in your name in order to be part of that review, but Bill Ferris and so on. There's a lot of other guys there, but that's the one I remember the most. And in 2016, they looked at the R&D and said, look, it's not really doing what it's supposed to do. There's not enough spend in Australia, so let's change it. And so they proposed some changes, and then there was another committee, and then they proposed some more changes, and then they brought out a bill. And in that bill, everyone's being against that bill. No one liked it. It was bringing the rate down from 43.5 to 41 for any entities with turnover under 20 million. And it was bringing the rate for the larger entities down as well. So no one in the industry did like it. It was complicated. They had an intensity rate, and it was just a mess. So the bill went through. It didn't pass. Went in, introduced again, and it just stayed there. And then COVID hit. In some ways, maybe COVID was a godsend, because in some ways the budget that we had on the 6th of October, they rethought it and they said, no, we're going to expand R&D instead of contracting it. So over the last few years, I think it's gone down in expenditure because, you know, AusIndustry has been a bit difficult. The ATO has been difficult. It's almost like they're applying a narrower definition to what's in the legislation, and they're almost not allowing people to have the R&D, and especially the software developers. So with COVID, the government said, well, in light of the continuing economic consequences of COVID, we want to make sure that Australia recovers. And so what they've done is they've changed what was there, and there's new law. And that basically nothing changes for 30th of June 2020, 2021, but it'll be for the 2022 year. Next slide, please. I'll go through that in a minute. So just to remind you all where we're at today. So if you look at the second column there, in 2020, it's 43.5. That's your rate for under 20 million. Okay, so we're talking here aggregated turnover of under 20 million, and I'll talk a little bit more about that in a minute. Basically, that's your company tax rate plus your net benefit. Some people like to look at it as a net benefit. If that confuses you, just go 43.5. That's what you get, your company tax rate plus a bit more. And that you can get in the hand All right, if you have taxable loss. And in 2021, it's still 43.5, fantastic. And the rate has gone down. Your tax rate will go down to 26. So your incentive is increased. Now, as you can see, I've got a third line there. Some entities would be 30. I don't think hardly any would be 30% if they're under turnover of 20 million. That is really more for passive entities. So next slide, please. I just wanted to show you the comparison though. If your aggregated turnover is over 20 million, so the larger entities, it's 38.5 right now. So at 30th of June 2020, it's 38.5. At 30th of June 2021, it's 38.5. Now there is I've got the net benefit being the 13.5. It just really depends on where you sit on the rates. Like if you're under the 50 million mark or not, sorry, under the 20 million mark or not. But if you're over 20 million and between 50, it's 38.5. You can see what the rate change is there. It's quite confusing, but effectively over 50 million, again, it's still 38.5. And that is going to be the same next year. And it's only when we look at 2022 that this new legislation comes into play. Next slide, please. So just as a reminder, you have to be a company to do R&D. You have to own the IP, unless you're foreign owned and the foreign entity owns the IP, then there is a way to have an agreement that the Australian entity would use the IP. You have to bear the financial burden. So if you're getting reimbursed for the R&D you're doing, it's likely it's not bearing the financial burden, and there's some clawback provisions. Your spend has to be greater than $20,000. Unless you're with a research service provider or a CRC, which is, universities and so on that you're doing the research with, that can be less than 20 to start with. But you have to think about, would you apply for that? And I think yes, if you were just starting a project and it was going to be more in the future. Have you got core and supporting? That is crucial. You have to have core activity, and a lot of you would already understand what that is. But I'll run through that in a minute. And documentation, document. How do you support what your application looks like? How do you support that this is not ordinary business? And that is the documentation that sits behind it. So what documentation are we talking about? We're talking about timesheets, how you split the time up. You're talking about the project overview, talking about project specs, talking about maybe emails, minutes to directors' meetings that may have discussed it, etc. Next slide, please. So core activity, as some of you know, is you have to basically, you don't know the answer. So you've got to carry out experiments where the outcome cannot be known in advance. So you don't know the answer and you carry out some experiments. Sounds all fairly easy, not so easy for software developers. You need to apply a systematic progression of work based on the principles of some established science. So it's got to be a bit technical, okay? It's not just, oh, how do I do this? Oh, yeah, look at this. It's got to have some science behind that or some technical difficulty. And you have to proceed from that hypothesis area into observation and evaluation to lead to a logical conclusion. Now, I've had this said to me many times, Mariana, software does not work that way. I understand, but that's the way the legislation works. And there's ways of putting it in paper in order to put an application. And that software development has been one of the areas that is a grey at times. At times it's very obvious. It's software development, but it is not ordinary business, but new, innovative. They don't know the outcome. They have to do experimentation, being iterations of some sort of code that you're writing. The next point is, conducted for the purpose of generating new knowledge. So you have to want to be generating new knowledge, not something that's already known. Now, by creating a new or improved, you can have an improved product, material, process, device, or service. Now, process, a lot harder to prove, but it is possible. And next slide. So the pitfalls. So the main thing we wanted to just discuss here, some of the pitfalls and traps, some of them very basic, others not so. So it can't be a trust, partnership, or individual to carry on R&D. It has to be a company. That is key. Now your spend has to be over 20,000. Unless you're a research service provider or a CRC, if you pay them to do your research, it can be less than 20. But if it is less than 20, is it worth it? Is it worth doing R&D or getting someone like myself to do the work and assist you? What's the cost of doing it versus the benefit? And not just the cost of paying someone, but the cost of your organisation spending the time and effort. Also consider one thing some have gotten wrong is what the aggregated turnover is. So you as an entity may be under 20 million, but who owns you? If there's a majority controller and overseas entity, you have to include their turnover. Or the venture capitalists in there, you have to include their turnover. So it's only where control is indicated that then they would effectively include the turnover and maybe over or under 20 million. And it's important because under 20 million, you get a refund. Over 20 million, you get a rebate. And that rebate you can carry forward. That's great. And offset it against tax in the future. Core R&D. Now, this definition hasn't changed over the years, but AusIndustry have been applying it narrowly. And it's all come to light. And I think from cases themselves, I know from cases themselves, they've actually proven AusIndustry wrong. So basically, if you want to have an application of an existing technology and applying it in a new manner, that's accepted. And there's a case on that. Now, AusIndustry, with the software development, the biggest issue has always been that AusIndustry guidance has been contradictory to the legislation. It's prescriptive in its format, where software development isn't. It's largely focused on why not R&D instead of incentivizing it and saying why it is. Better guidance needs to come out, and I think that has been really outlined in a lot of the reviews that have happened. Documentation, document. And they acknowledge that you need sometimes less than formal documentation. You don't have to necessarily have a business case there. But documentation is important to prove your point. As well, there's been a review from the small ombudswoman. I always say ombudsman, but it is a woman, and she reported a fair amount of issues, and they're very common issues. Like, for example, the delay the AusIndustry has with review some of these R&D audits, the time that it takes, and Catherine's going to probably run through that in more detail. Just the definition of what is software development, and so on. Now, expenses, salary and wages, you don't have to keep timesheets, but how do you prove it otherwise? So timesheets are recommended. You've got a project management system, use that as well. I've just put some cases there if you ever want to read a bit more. Contracts, make sure they're in Australia. There's an interesting one where you contract with another Australian company to do some software development, and they're doing a task. Who do they use? Do they go overseas and use people overseas? You're paying an Australian entity to do the work in Australia. So, you've got to be careful there. Depreciation. If you're looking at claiming depreciation under R&D, you can't claim the instant write-off. Like, we've had these fantastic instant write-offs recently, with the budget changes up to 150,000 or anything really, actually, no limit from the budget onwards. And so, is it better to just claim the expense in the year that you make it, or is it better to depreciate it for R&D purposes and get the uplift? And that's a question you have to talk or think about and compare. But if you get the instant write-off and claim it as a tax deduction, you don't get R&D on it. But you can get R&D on it if you just claim it as normal depreciation, over the life of the asset. Overheads. It's very clear in the legislation. It says to the extent. So that means you apportion your overheads. What apportionment method do you use? Previously, before 2011, when the tax incentive came in and it was a tax rebate, tax concession, they basically said that you could use your R&D salary and wages over your total R&D salary and wages. So apportionment, and in software development makes sense, right? Because that means your software developers that are doing the R&D, they're on premises, so they'd be using maybe rental, there'd be some insurances. You know, I just think you just got to be careful what you include as your overheads or exclude for apportionment. You wouldn't include marketing, for example. You wouldn't include necessarily some insurances. So just to be careful of what you're including, have a good look. Ineligible activities. So make sure, I always like to say, but work backwards, because you need to make sure that some of your expenditure is excluded, or some of the activities might not really be R&D, they're excluded R&Ds. So market research, feasibility studies. Oh, does it, you know, will this fly? Will this work? I'm going to go and check the market. That's not R&D, okay, and that's specifically excluded. Not to say if you are doing some research, preliminary research before you start your R&D, that's certainly included. And the nature of the program, it's retrospective. So if they audit you today, they could go back 3 years if the project's been started for 3 years. Next slide, please. Okay, so budget changes. So, and there is legislation that's already been passed. So from 1 July 2021, we don't have to wait any longer. Except for 2022. What we're going to have is the tax rate is going to stay at 43.5. And the difference is what's happening is that it's going to match the company tax rate. So it'll be fixed at 18.5 plus whatever the company tax rate is. And as it happens in 2022, the company tax rate will be 25 for entities with turnover under 50 million. There's no cap anymore. So the discussion about capping it, no cap for under 20 million. Next slide, please. Okay, so now we're talking about an over 20 million turnover. These guys not getting a refund, they're getting a rebate. Now the rebate is much better. They do talk about, you know, a two-step approach, premium rate. So the more you spend on R&D versus your total expenditure, I'll give you an example in a minute. So the more you spend, the higher the rate. So the incentive is going to be a 16.5 plus your company tax rate. And I'll show at the end how that works. So the first 2% of your R&D expenditure, if you like, or 2% of the spend will be 8.5, and anything over that is 16.5. It will be capped up to 150 million. That's a lot, right? I haven't done one of those yet. Okay, next slide, please. So I just wanted to show how it worked. Previously, it was four tiers, and then the legislation changed to 3 tiers, and now they've made it 2 tiers. A little bit easier to calculate, a little bit easier to understand. Now, I've picked an example which is in the bill, and it's probably over the top in the sense that it's 160 million spend, but I just like that number. So let's look at 2022. We're 2 years down the track, and we're in that financial year. We're doing our R&D. We've spent 160 million. What can I claim? So I've got 160 million spend on R&D alone. My expenditure on everything else is $1 billion. I just like saying that too. So what's our intensity rate? Well, it looks at, well, it's capped at 150, so I can only use 150 million. I put that over 1 billion and I get 15%. So if I look at my intensity rate at the top, my premiums, 8.5. No, it's more than that. So great. Sorry, 2%. So greater than 2%. So it's 15. Great. So then I go through and calculate it. Now my turnover is greater than 50 million. So I'm at the 30% rate. So my excess of 10 million, let's start at the bottom, is excluded. That's out. 2% of 1 billion gives me 20. This is just the way it calculates it. And so then I get the 20 million, I get my intensity rate of 8.5 plus my tax rate of 30%, because I've said it's 30, I get 7.7 million. And then anything over that, I get 16.5 plus the tax rate. So I get 60 million. So you can see there, and also the excess of 10 million, I haven't lost it. I've just get the company tax rate of 30 cents in the dollar. So I get back 71 million, let me just say it that way. And that's a rebate off my tax. Now that's going to be big for the bigger end of town, the over 20 million. But over 20 million for family groups is not necessarily that big either. So, and for some large foreign owned. So that rate is much better. So if you look on the next slide, this is my last slide, so I won't bore you too much. You can sort of see here, what I'm trying to do is that, you know, the rate is, the more you spend over 2%, it'll be 16.5 your rate for those bigger entities. So this is over 20 million turnover. So you can see there that if you looked at, if we were in the 30 cents in the dollar rate, we'd be getting 38.5. But now if we've got such a big spend, we've got 46.5. So we've actually, with a 30 cents in the dollar rate, we're actually getting more from the R&D. So it's expanded the R&D. So the message out there is, because of COVID, we've expanded the R&D rate for the larger entities. And for these smaller entities, we're going to make it 41. Well, now we're still keeping it at 43.5. That's the message to send out there. So what happens when you, okay, you've gone through this, you've done your application, you've been running smoothly for a couple of years, AusIndustry comes along and wants to audit you. Catherine, can you lead us through that example?
No worries. Thanks, Mariana. So what I'm going to talk about today are some of the steps that you need to apply for if you need to have a review of a decision of AusIndustry in the AAT. I'll go through the actual timeline of a dispute that I ran recently. I'm also going to look at whether or not you have an obligation to repay that incentive to the ATO if AusIndustry refused to register your activities. I'll go through some lessons that I've learnt on the ground from running these matters, and give you some tips at the end on how taxpayers can avoid an R&D dispute with AusIndustry. So just to start with, next slide please, Tanya. These are the steps that you would take in order to get yourself into the AAT. So AusIndustry will usually register your activities that are applied for. At some point, AusIndustry may then notify the taxpayer that they intend to examine their registration and undertake a compliance review. And they may review 1 or more years. AusIndustry will then review that registration, and they may seek some further information and documents from the taxpayer. And then they'll make a determination that the activities claimed are not R&D activities. In that case, the taxpayer can then seek internal review of that decision. And what this involves is having a separate person at AusIndustry review that original decision. And that separate decision maker may then go through and collect some more information and documents from the taxpayer and explain, consider that decision. They will then confirm or vary that original decision. If they there's still a decision that's adverse to the taxpayer and they confirm their original decision, the taxpayer is then at a point when it can apply to the Administrative Appeals Tribunal for review of that internal review decision. Next slide, please. So this is a timeline of a matter that I ran recently. So I'll just step you through how long it took to get from the point of lodging your application to then ultimately having to apply to the AAT. So getting from steps 1 to 5 that I outlined previously. So the taxpayer lodged their application on the 5th of July 2016. About 8 days later, they received notification from AusIndustry that their registration had been accepted. It was about 10 months later that AusIndustry then notified the taxpayer that they would examine its registration. There was then a period of a number of months where AusIndustry sought that further information and documents from the taxpayer. The taxpayer provided that information to AusIndustry, and then on the 19th of June 2018, AusIndustry made a determination in relation to those activities that some of the activities weren't core or supporting R&D activities. So the taxpayer then decided to seek an internal review, and they did that in July 2018. And they asked AusIndustry to undertake that review. So the matter went to a separate person at AusIndustry, and they sought some further information and documents from the taxpayer, which the taxpayer then provided in November 2018. And then some 4 months later, in March 2019, AusIndustry notified the taxpayer that they'd confirmed their original decision. It was then about a month later that the taxpayer applied to the AAT in order to review that internal review decision. And you can see there that I've said it's at that point also that the AAT will then seek to obtain some security or recover the R&D tax incentive. But I'll cover that off at a later slide. Can we move to the next slide, please? So we're now in the AAT, we've lodged our application. What are the steps that are involved? So the taxpayer is referred to as the applicant because they're the person who applied to the AAT for review of their decision. Innovation and Science Australia is the respondent. So they're the party that the proceeding is against. I'll just try and refer to them as AusIndustry just for simplicity's sake. So AusIndustry is the party that effectively delivers the tax incentive program on behalf of ISA. So the first stage of a matter in the AAT, which I've called reviewing the case. So this is where we're going to file the application, we're going to review the documents, and we're going to brief counsel. The next stage is preparing evidence. So what we have to do is we need to be able to explain to AusIndustry what it is our case is and why we say that we satisfy the legislative criteria. In order to do that, we need to prepare witness statements. And a lay witness is someone who may work in the business. They may have been involved in the R&D project and they have intimate knowledge about why experiments were undertaken, what happened at a particular time, who was involved, just the who, when, why, what. Those people may work in the business or they may be ex-employees who previously worked in the business. We'll also need to obtain expert witness evidence. So an expert is someone who has particular knowledge in an industry, who can say, well, this was known in the industry at the time, or they'll explain why, in their view, this is following what Mariana outlined being those principles of established science. Yes, this is common in the industry to do it in this particular way. The other document that we'll have to file with the tribunal is called a Statement of Facts, Issues and Contentions. And this outlines your legal arguments, which is effectively why you're saying you satisfy the legislative criteria. So that's the taxpayer will file that evidence, and then AusIndustry will then file their evidence. They usually don't have lay witnesses because they're not involved in the project, but they will put on expert evidence and they'll file their own Statement of Facts, Issues and Contentions. When the taxpayer receives that evidence from AusIndustry, they can then consider whether or not they need to file what's called reply evidence. And this is evidence where they might want to put on some more witness statements from both the lay and the expert witnesses in order to counter some of the arguments that the AusIndustry has put in their evidence. So once all the evidence is filed, the next stage is to see whether or not we can attempt to resolve this before the hearing. And there's two ways you can do this. We can do this through informal settlement discussions or through a conciliation conference. So informal discussions would just involve the lawyers for the taxpayer and AusIndustry talking to see if the parties can try and come to some kind of an agreement. If a conciliation conference is required, this will be set by the tribunal. And this is where you'll have someone from the tribunal who's there also trying to bring both of the parties together to the table to see if it can be resolved. If the parties can't resolve the matter at that point, the matter will then ultimately move on to a hearing in the AAT. Next slide, please, Tanya. So this slide outlines the timeline for that matter that I was working on. So we filed our application on the 16th of April 2019. About a month later, AusIndustry then file what's known as the T documents. So these are the documents that they say the tribunal needs to have before them in order to determine the matter. And they're all gathered from the period of undertaking those reviews and gathering that further information during that audit process. The tribunal will also set a timetable for evidence, and the timetable will state that the taxpayer will put their evidence on first. So the taxpayer filed their evidence, in this case in November 2019, and then about 10 days later, they filed their Statement of Facts, Issues and Contentions. It was almost 5 months later that AusIndustry filed their evidence, and they only filed expert evidence. And then a week later, they filed their statement of facts, issues and contentions. As a result of receiving that evidence, the taxpayer decided it was important that they wanted to file reply evidence to contradict some of the things that had been put by AusIndustry. So the taxpayer filed their reply evidence, and then after that, the taxpayer made an offer of compromise to AusIndustry, and AusIndustry accepted that offer. So in order to record that acceptance of the agreement, the parties file what's known as consent orders with the tribunal. And the tribunal accepted those consent orders, and that settled the proceeding. If, however, the parties hadn't been able to settle at that time, what would have happened? Well, I'd say within about 1 to 2 months, the tribunal would have set a date to have a conciliation conference, or a formal conference for the parties to bring them together. And then if they couldn't agree on that, the matter would have moved to an AAT hearing. Now, I'd say I wouldn't have expected that AAT hearing to be on before early next year if we hadn't been able to settle at a conciliation conference. From there, you're then waiting for an AAT decision, which would probably be somewhere in the vicinity of 6 to 9, 10 months for the decision to be handed down. And then I've just outlined there, if the decision was adverse to you, you may or may not have grounds upon which to appeal. You could then go through to the full federal court, and then if you had any other avenues of redress, you may then also be able to seek leave to appeal to the High Court. If that leave was granted, the High Court would hear the matter, and then ultimately the final decision would be the High Court. Let's hope we never have to get that far. Next slide, please, Tanya. So obviously undertaking this kind of a project can be quite costly. So there's a number of factors that will affect costs. So firstly, how many years are in dispute? You may have different projects running across a number of different years. So if AusIndustry are investigating you for various years, you may need to put on lots of different evidence to support the different projects that are going on. And also the project may change over those years. And so the more years that are in dispute, the more evidence you're going to have to put on, both documents and your statements. Secondly, the complex nature of the issues in dispute can affect your costs. Obviously, the more simple the proceeding, the less expert evidence you're going to need. So obviously with R&D, it's usually quite technical. And so it's necessary to explain those technical concepts to ISA. And that can just take a lot more time and require more evidence. Thirdly, I'd say the volume of documents that you have. So if you have a lot of documents, then there's a lot of material to get through. Again, that's affected by the number of years of the dispute. The other factor, which Mariana mentioned, is your record keeping. AusIndustry really want to see contemporaneous record keeping. So they want to see what you've prepared at the time that the experiments were being undertaken. What have you done before it? What have you done during it? It's a lot harder to run a case when you're preparing documents years later and you don't have those records that were created at the time of the experiments. The last factor that I've said that will affect the costs is the number of witnesses. So, again, if you need a number of people to explain a particular project, it's going to cost more. If you only have one person who is across everything, that may still cost a bit, but you're not having to deal with 4 different witnesses if you've got it all in the one person who knows what's going on and has that knowledge. I've also said there the availability and reliability of key lay witnesses. As we saw from the slide before, there are a number of years from when an application can be lodged to when we can get final resolution of the matter. If you've got lay witnesses who have left the company, they might be former employees who are no longer with the company. Perhaps they didn't leave on particularly good terms. If you then come to them years later and ask them to be involved in the case, they may not be as willing to assist. So again, the availability and the reliability of those key lay witnesses can affect your costs. If you can't get that one key person who's no longer with the company, you may need to get evidence from, say, 3 other people who are currently with the company. Also, they're having to engage expert witnesses. Depending on how technical it is, you might need a number of different experts. Next slide, please. So this slide outlines the potential costs. Now, obviously, Each matter is different on itself. You would need to look at how many years are in dispute, the nature of the issues in dispute. But what I've tried to do here is just give you a really broad idea of like a worst case scenario if we had to run a proceeding to a full hearing in the AAT. So I've grouped this along the lines of the stages that we talked about before. So the first stage was that reviewing the case. So what I've allowed for in this section is preparing the application, reviewing the documents, briefing counsel, and just your general case management. So when the lawyers are dealing with the other lawyers throughout the course of the proceeding. And I've allowed there 33 to 63,000. The next stage is preparing evidence. Now this is going to be the most costly stage of the proceeding. So this is when we're preparing our lay and expert witness statements, the statement of facts, issues and contentions, and any reply evidence. Reply evidence is particularly difficult to estimate because firstly, you don't even know if you're going to need to prepare it because you've got no idea what the other party's evidence is going to be and if you're going to need to do it. But I have made an allowance in here for some reply evidence. And I've said in here we allow between 73 to 185,000 for that stage of the proceeding. If we then we've prepared our evidence, we're then looking at what are the potential costs moving forward. So this is when we've got our conciliation conference, the settlement discussions, and the hearing. And I've allowed in here $72,000 to $100,000. So that's all your lawyer's fees that I've just gone through. In addition to that, we'll have some other fees. So we need to be aware of filing fees. So the current filing fee cost is $952 for an AAT dispute. I've allowed in here $100,000 to $200,000 for counsel. Now, that's really allowing for just one senior junior counsel, if I say that, so not a silk. On the last matter I worked on, AusIndustry had both a silk, so a senior counsel, and a junior counsel, but we just retained our junior counsel. If you'll start retaining senior counsel, the costs will just escalate. And so I haven't allowed for that in this, but that's something to bear in mind. You also need to consider whether or not you're going to need an e-discovery provider. So if you have a lot of documents, you're going to need an e-discovery provider to host those documents, just because of the sheer volume of them in order to work with them. And I've allowed in here $20,000, so it's roughly about $1,000 a month. It depends on the size of the data that you need to store as to how much it will cost and how long the proceeding goes for. And then you get charged for when you're doing uploads and processing costs from that provider. The other costs that you need to be aware of is witness fees. And I haven't allowed for those because, I mean, who knows what, it depends on who your witnesses are. If they're current employees, you're just going to have to pay them their salary. But if they're ex-employees, they may charge you a consulting rate. Or if they're experts, they'll have their own particular consulting rate they'll charge. So all up, when we look at that, I've said on a worst case scenario, I've allowed for, it's going to cost around $299,000 to $569,000. Next slide, please, Tanya. So this slide is just looking at how ISA has resolved some of their R&D disputes. So this is the most recent data that's been provided, and this was released in their annual report late last year. And it's current as at the 30th of June 2019. So ISA and the ATO are jointly responsible for administering that scheme, and AusIndustry, registers the activities, but then the ATO sort of manage the rules for those eligible entities. So the ISA reports on the matters that proceeded to litigation in its annual report. And you can see here that as at the 30th of June 2019, they had 41 active applications in the AAT. Now, of these, there were 35 separate proceedings, which means a number of proceedings had two proceedings joined together, which would mean that ISA has investigated different years at different times, and then they've brought the proceedings together. They also had one matter before the federal court. At the ISA, at the AAT, sorry, ISA was involved in 57 matters during that year. 22 of those were initiated in prior years, and 35 of those applications were received in the 2018-19 year. And ISA have told us that 2 of those applications that were received related to applications that were already before the AAT. So they account for some of those doubling up. So what did they manage to resolve in the 2019 financial year? Well, they resolved 16 matters. And how did they do that? So 2 ended up going to the AAT and had decisions. 8 were discontinued or withdrawn by the taxpayers. 5 were resolved through consent orders, so similar to what happened in my matter. And 1 application was dismissed due to the taxpayer's non-compliance. So you can see there that not many matters actually end up going through to a final hearing. Next slide, please. So we've got an obligation to repay the tax incentive. So if you've received a refundable tax incentive that ISA later reviews and AusIndustry determines that they won't register those activities as core or supporting, the ATO will come knocking and ask you to amend your tax return to repay that incentive prior to the AAT proceedings being concluded. Now, for companies that are relying on the R&D tax incentive, this can cause you a great financial difficulty because you may not have the cash flow. This is a number of years later. You're likely to have already spent the incentive. So what can you do? Well, there's a couple of options available. First of all, you can try and negotiate with the ATO to defer the repayment until after the conclusion of the AAT proceedings. The ATO has been really good at doing this lately. They may require you to give some security, and you'll have to negotiate with them what they would see as an acceptable security. Another option, which I have been involved in doing one of these, was we issued a request for stay. And the purpose of this was to force AusIndustry not to advise the ATO of the decision that had been made in order to bring them to the table because they weren't negotiating at that point. So we forced them to the table. I would say in the current COVID environment, that's not necessary because I think if you start engaging with the ATO early at the moment, they're really wanting to get cash back into businesses and making sure that they can survive. So I think the ATO would be willing to negotiate at this point. If you've got future years, say you've been denied a particular activity and it relates to a number of years, it may be appropriate that you don't actually receive that refundable tax incentive pending the conclusion of the AAT proceedings. So you might actually still complete your applications, but just don't take the incentive if you then will have to pay it back. But if you do get a successful outcome in the AAT, you can then still take that incentive once the proceeding has been concluded. And next slide, please. So having run a number of these matters over the last couple of years, what have I learnt? So the first thing that I wanted to share is that you need to ensure that you've met the legislative criteria. So this means that you can't just send information to AusIndustry without explaining why it's meeting the legislative criteria. You've got to explain all the pieces of the puzzle to them. So they don't really care how innovative or useful your project is. You want to tell them about your amazing project. They want to tick their boxes and make sure you've met the different criteria that sets out in the legislation. And this also includes ensuring that the activities aren't excluded activities. So in a recent case of Avila Resources, the AAT found that many of the activities that were undertaken to satisfy some statutory requirements and therefore fell within one of the exclusions in the legislation. Now, Avila tried to argue that the activities were undertaken in parallel, but the tribunal concluded, well, even if the claimed activities were carried out for a dual purpose, the exclusion would still be engaged. So first of all, make sure that the activities meet the criteria. Secondly, ensure the activities that were registered were actually undertaken. Now, this might sound a little strange, but if there's a large gap of time between conducting the experiments and lodging the application, if people have left the organisation, you might have someone preparing the R&D application who actually wasn't involved in undertaking the experiments at the time. Now, the tribunal's review jurisdiction is confined to determining what activities have been registered in an application and have been the subject of that internal review. So you can't come in and bring in new activities later and say, oh, I forgot to put that in my application. You've got to make sure the application covers it first off. Because it's a lot harder to build a case if that application is missing those activities or it records incorrect activities. So this is why it's really important to get advice from Mariana. Thirdly, You need to provide contemporaneous evidence. So this is one of the biggest boxes that AusIndustry want to see ticked. In that Havila Resources case, the tribunal had accepted a view of a senior member in a previous AAT case, where they said the applicant cannot succeed in establishing the requirements in the absence of detailed documentation recording the process of each activity as it develops. Now, this can be challenging for taxpayers because you're busy running your projects and there's often a lot of money invested in the activities. And so when experiments are being undertaken, you're focused on undertaking the activities and not necessarily in the record keeping. It's not always a priority, but you just need to make sure that you are still keeping those records as you're going, because the contemporaneous documents are critical when it comes to proving your case later on. The next point is we need to explain the technical concepts in plain English. So science is technical, and the activities that you're undertaking can be really hard to understand if you're not familiar with them. AusIndustry will have technical people working on them, but they're still not going to be experts and have as much knowledge about the particular area as what you do. So it's just really important that you can sort of bring the technical concepts down into plain English and use helpful diagrams to try and explain things. So you need to relate each of those concepts back to the legislation. As Mariana said, how is this new knowledge? Why is the outcome can be determined in advance applying a systematic progression of work? You know, is it based on principles of established science? Does it proceed from hypothesis to experiment, observation and evaluation, and then lead to logical conclusions? And you need to make sure the activity is not an excluded activity. Next, I think it's important that you may need to demonstrate links across years and activities. Now, in a case recently called Coal of Queensland, the AAT made it clear that regard is not to be had to the whole project, but to the actual registered activities conducted in that relevant year. But the AAT held that the evidence of the activities which fell outside that 2012 year were only relevant in order to shed light on the characteristics of the activities conducted in that 2012 year. Next, you really need to make sure your hypothesis is established and recorded prior to undertaking the experiments. So it's much harder to try and piece together this information and to find the hypothesis. And again, I understand it might not always be easy to do at the time, but if you can do it, do it. Because I love to see that document. Show me the document where you've recorded your hypothesis before the activities were undertaken. It's the last thing I've said here is it's important to select the right expert and brief them appropriately. So if you do find that you end up in the tribunal and you're going to need to rely on an expert, you need to make sure you get the right expert. So in the case of Havila Resources, the expert disagreed with aspects of the statutory definition of core R&D. So he concluded that the R&D did not need to follow a systematic progression of work contemplated by the Act, but could simply be data acquisition followed by an assessment that the R&D did not need to commence with an hypothesis, which is completely wrong. The expert's conclusions didn't address the legislative requirements of the core R&D activities and did not assist the tribunal in determining whether the requirements were satisfied. So the AAT gave very little weight to that expert, that was the taxpayer's expert, and instead they accepted the evidence presented by AusIndustry's expert. So important to brief the right person. Lastly, I just wanted to outline here how you can try and avoid an R&D dispute. So first off, it's really important that you prepare detailed applications with evidence to support your assertions. So important that the application reflects what actually occurred. You need to talk to people and collect documents to support those assertions. And if you can do that at the time, it's going to be much better than trying to do it. If you change your hypothesis, you need to record the what, why, how, and when that happened. You need to undertake accurate record keeping. So you need to show what you did, what the expenditure that was claimed, the assets that were used. Show the specific ways in which your R&D was carried out. Track your experiments to the activities that have been claimed. You need to ensure that your evidence is contemporaneous. So as I said before, people can move on or be made redundant, and then they might not want to assist you later on. So it's a lot easier and less costly if you can gather that relevant data at the time. This is particularly relevant to the literature review. So you need to just demonstrate what knowledge was known so that you can show the new knowledge that you're trying to discover. It's a great idea if you can make someone responsible for R&D compliance. So R&D applications are worth millions of dollars, and therefore they deserve attention. So by undertaking an audit, it's costly and it detracts staff from their key day-to-day jobs. By having a dedicated team member to gather that evidence, to capture the information needed, you might save yourself a lot of money in the long run. So the R&D projects are often fast moving and they change on the go. So you need to ensure that someone is recording that information and the changes that are happening in order to be able to prove this up to AusIndustry later on, that you have satisfied that relevant criteria. For larger organisations, this might mean that this is someone's entire role. But for a smaller organisation, it's likely to be one of the many tasks of, say, a CFO or a member of the finance team. I've said here, if you can establish an R&D committee, so recording the R&D projects could easily be built into existing meetings. Can you put them into your monthly board meetings, your JV meetings, your finance team meetings? If you can build that in somewhere and just make it a permanent agenda item, it will become a focus for you. So if R&D is critical to your business, then you want to ensure that you're accurately recording the what, when, how, why that you are undertaking of those risk experiments. And lastly, I've said here, it's important to engage with AusIndustry. So don't delay in responding to requests for information. If you can't meet a deadline and you need more time, actively engage with them to obtain an extension. Explain to them why you need the extension and when you'll be able to provide that information. You'll generally find that they just want to work with you to try and get the outcome together. That was it. Thank you.
Thank you, Catherine. We're now moving on to our Q&A, and there doesn't seem to be any questions in our control panel Zoom box. So therefore, I just wanted to ask Mariana or Catherine if they had any final thoughts they wish to add.
No, I just wanted to say, thanks, Catherine. I think it was great that you outlined some of those things. I mean, a lot of clients, some of them under 20 million, they want to do the R&D, get the refund. And a lot of the if they go that step further, it's a costly exercise, as you say. And so really, if they try to defend it themselves, they have to make sure that they've got all the documentation. And is it worth it? You know, I think the cost of the legal fees and everything has to be worth it. And now that the rate is going up, it's more beneficial. And you can sort of see where those organisations with a turnover of more than 20 million, again, that's their expenses. Some of them can be quite high, and that's where it might be worth battling. I mean, in practice, what I've seen, or in reality, if you like, is that I've seen a lot of cases, and Catherine, correct me if I'm wrong, they're in the mining industry, you know, or, I mean, there has been some in the software, but more from the tax office perspective. So it is a bit, they don't really sort of sometimes put out there the everyday organisation, the everyday software provider. You got any comments on that?
Yep, I agree with you. The last number of cases, I think the last 3 cases that have come out of the AAT have been in relation to mining cases, and that would be just the money involved. I think it also, the cases that go to AAT, I don't see AusIndustry taking cases there that they're not pretty confident in, that they think they can win. So there might be that some of those other cases have actually been settled by consent, or they might be part of the ones where the taxpayer has then withdrawn the application and they've accepted that maybe they've just filed it to you know, preserve their rights, but then when they actually start gathering the evidence, they realise they might not actually be able to satisfy the criteria, and they might decide to just end the proceeding before, you know, incurring any further costs. So I would say that some of those smaller matters might actually just make it to tribunal but not end up in a hearing, because either the taxpayer or AusIndustry has decided, hang on a minute, I don't want to take this any further.
Yeah, and that's sad, because then obviously we don't get a Guernsey in, so no one gets to see what's really happening. Is there a way of seeing what's happening from, you know, there isn't there? There's no, unless it goes all the way through the courts or the AAT, there's no way of really seeing it.
No, unless it goes to a hearing. And this is, I mean, you sort of tend to find this, I find this in the income tax perspective as well against the commissioner. Commissioner's not going to take on cases that he doesn't really think he's going to be able to win. And I just say the same thing for AusIndustry. the cases that are going to go there are ones that they're obviously, you know, they'll take advice. Like on my one, I said they had senior counsel and junior counsel on it. So they were taking my case very seriously. But, you know, we got to resolve the matter. So none of you get to see it and see the benefit of what was agreed. So yeah, it is a shame, but unfortunately, you know, that's the way we're working at the moment.
And I think taken from the budget, I think that's it's good news in the sense that they have opened it up a bit more, in the sense of keeping the rate high, competitive. New Zealand is 15 versus our 18.5, if you like. So it is still worthwhile doing the R&D here in Australia instead of shipping off to New Zealand. I think also that they are paying attention to what the industry, I mean, even though the industry seems to be, everyone seems to be hitting their head against a brick wall at times, it feels like. I think there's been enough going in to the AusIndustry and government saying, you know, we need some more guidance on some of these areas. So in time, they may bring out some more
guidance. I just
guidance.
wanted to thank Mariana and Catherine for their presentation this morning, and I've just launched a poll if you want Mariana or Catherine to contact you directly. The recording and the PowerPoint slides will be sent to you directly. Thank you for joining us today, and thank you, Mariana and Catherine, again.
No, thank you, and thank you for listening. Thanks, Catherine.
Thanks very much, Mariana.